murder, the state has not proven any, it has not given any evidence of a cause of death. They have not shown any evidence that Christopher caused Melissa's death. They've not shown any evidence that she died unlawfully. On felony murder, they've not given any evidence that an aggravated assault occurred. They've not given any evidence that an assault occurred. They've certainly not given any evidence that it occurred with an object that could result in serious bodily injury. And they've certainly not also given any evidence that an aggravated assault occurred that caused her death. And they've not proved the cause of death. In neither case have they proved an intent to carry out either an aggravated assault or a murder with malice aforethought. In this case, Your Honor, is the evidence of guilt is only circumstantial, and the court must rule out every reasonable hypothesis that would support his innocence. They have not ruled out the fact that other people, including the victim's parents, including the victim's uncle, Martin Eric Jackson, including any number of random people in the area, could have carried this out. There are a number of reasonable hypotheses, and we've given evidence for some of them. And the court is authorized to apply that standard in granting a directed verdict. Just a second, Your Honor, please.
Sure.
The state has given some evidence from which, from what we've talked about with prior difficulties regarding the incidents of alleged domestic abuse that occurred in July of '98 and at some undetermined time before that. But when you're considering what a reasonable juror, well, I think your jury instructions covered as well, as far as what a reasonable juror would be allowed to consider as toward the elements of the crime. They cannot consider or infer character. They may not infer from those things that he had the character to commit other such crimes or wrongs later. In other words, they can't use that as propensity evidence. So they can't say, well, he did this, he may have hit her on one other occasion, so he must have done it later, and therefore that fulfills one of the elements of the crime. They can't do that, and this court can't consider that. And as far as prior difficulties are concerned, the finder of fact is only allowed to use that to consider a state of feeling between the parties. So I would say there's an abundant lack of evidence in this case of intent and of the elements of the crime, and so we would request the court grant directed verdict at this time.
Thank you, Mr. McDermott. Who will I hear from for the state?
Me, Judge.
Mr. Fawcett,
Yes.
your response?
Your Honor, I would cite two cases as a, then my computer goes, one second. Your Honor, I would cite two cases as authority for the court at the basis decision on. The first case is Odom versus Hughes. That is a Georgia Supreme Court case, 293 Georgia 447, 2013. Second case is Miller versus Lynch, 351 Georgia Appellate, 361, 2019 case. It ultimately speaks to the decision before the court when there's a conflict and when there is no conflict in the evidence that's been presented by the state. Miller states the trial court may direct a verdict only if there is no conflict in the evidence as to any material issue, and the evidence introduced with all reasonable deductions therefrom shall demand a particular verdict. Where any evidence, even slight evidence, supports the opposing party's case, the directed verdict is improper. So, first, the state is not required to prove evidence of motive, but the jury is authorized to consider evidence of motive. In this case, I would cite evidence of three different potential motives for this defendant to murder Melissa Wolfenbarger. First was the pending state court case from the July 1998 incident. There was a battery, and even though Melissa wrote an affidavit saying that she no longer wanted to pursue the TPO. We know from the March 29th, 1999 date that that criminal case was still pending. I think the fact that that case was still pending and that Melissa was murdered and was unavailable to attend, her head being found a month after that case was dismissed when they couldn't locate her, I think the fact that there was a pending case, the jury can consider that as possible motive. I think that the fact that this defendant was aware that Melissa Wolfenbarger was seeing an individual he referred to as Mike, who we heard testimony from and confirmed and corroborated that. The fact that she was having an affair is another form of motive, possible motive for this defendant to murder Melissa Wolfenbarger. And we also know from Melissa's mother, the letters, and this defendant's own mouth that Melissa planned on leaving this defendant. All three of those are independent, separate, possible motives for this jury to consider as reasons why this defendant would want to have Melissa Wolfenbarger murdered. There are prior difficulties, and those prior difficulties further corroborate the battery that occurred on July 1998. There are three instances of the prior difficulties. The first in the beginning of the year, I believe it was February or March of 1998, where Tina Patton describes seeing marks around the neck of Melissa Wolfenbarger. Vividly describes that.
Where's the object?
As does the officer Marlon Sutton, describes the events that took place on July of 1998 when he, according to his report, observed bruises and abrasions on the person of Melissa Wolfenbarger. And then we have Thomas Dixon at the end of December 1998, which he's relaying information about the continual abuse that Melissa endured during that period, during that year, and also, again, how she planned on leaving him. I would say that from the testimony of the medical examiner's office, medical examiner, Dr. Terry in particular, her testimony was that she does not, in her expert opinion, believe that Melissa Wolfenbarger died of natural causes. That is from the circumstances of the facts that she reviewed, the fact that there were tool marks on the person, the bones of Melissa Wolfenbarger, on the neck, on the limbs, on the femur, the fact that the bags appeared to be situated to where she was, in her opinion, murdered at a different location, that those bags were placed there very recently to the time that they were located. Because of the rip in the bag, she isn't able to tell the time of death. You know that the head had not been outside of that bag for more than a day because there were no maggots, there were no insect activity. The doctor couldn't say whether or not the remains had been refrigerated and dropped off. That was a possibility. She also couldn't say, she couldn't say whether or not Melissa had been strangled because the parts of her neck were missing for her to make that determination. She couldn't say if she had been strangled. She couldn't say if she had been choked, stabbed, shot, or a number of other different manners of death were just not available for that determination because of what was missing. And I don't believe that the defendant should be able to benefit from how well he was able to dispose of her body. The statement from...
Is this real life? The defendant shouldn't be able to benefit is one thing. And then to say how well he disposed of the body, where he worked, your theory is that he went and put a body right where he used to work.
Dr. Cherry, is that the circumstances lead her to no other conclusion that it's highly likely that she died of homicidal violence. And I think that that in and of itself are facts sufficient enough that the jury should decide this case. I would ask that the court deny the defendant's motion.
So I agree with you absolutely regarding the murder charge, that there is evidence from which there's evidence in the record that would create issues for a jury regarding the fact that homicide occurred and the fact that Mr. Wolfenbarger may or may not have caused that homicide, which are issues for the jury. So I'm going to deny your motion on the count one for murder. I think for largely the same reasons, I should refrain from granting a directed verdict on the felony murder. But I mean, candidly, I do have some concerns about the fact that even if there are clearly facts, the circumstances of her being found, right, that would support an inference, right, a reasonable inference if the jury decides to make that inference that the cause of her death was homicidal in nature. There's not any facts from which we can determine that that any sort of weapon was used against her in any
Object.
offensive manner. So how do I reconcile that?
Well, so it is not required for it to be a weapon. A per se weapon.
Object.
So it's not required that the weapon be per se like a gun. Gun's per se weapon is by statute, but any object that has a possibility of causing serious violent injury.
Right, but there's no evidence of that. That's my point. I can infer that she was killed by homicide because of, for example, a jury could infer that
Fraud
from the
indictment.
circumstances of how she was found and how her body was dismembered and disposed of. But can you also rationally infer that she must have been assaulted with an object which, when used in the manner in which it was used, is likely to result in serious physical injury or death?
Yes, you can.
Okay.
And the reason why is because if she did not die of natural causes, there is the inference that there is an intentional act by the part of this defendant to cause her death. Whether
That
that
doesn't
is
answer the
poison,
question. Object.
that would be a substance that would cause serious violent injury. The aggravated assault could be the poison itself. If it was his hands around her neck and strangling her,
It's not, no.
the hands would be an object. We typically charge fists, feet, knees, elbows. All of those objects could be offensive weapons depending on how they're used. And it could be something that is man-made, like a gun, like a knife, like a belt or rope. And the point of the charging and the way the indictment is charged is because it is because there aren't parts of her that would allow for a determination, like the torso, for instance, like the neck structure. We cannot, with any degree of medical certainty, narrow down the limitless possibilities of objects that could have been used to kill Melissa Wolfenbarger. That's why, because of the circumstances of this
Determined.
case, dictate that the indictment be charged in a way to allow the jury to consider all of those possibilities. And so the court is going to instruct the jury.
Well, I mean, not necessarily. The DA could have elected to just charge murder,
Yeah,
because
no.
either you can or can't prove murder. They didn't have to charge felony murder. I mean, you said we had to allege it the way we did. That's if you chose to allege felony murder, right?
Right, having made that decision to
Right.
charge felony murder, I think that the intent was to give the jury the ability to consider all the reasonable possibilities of objects that could have been used to commit this serious violent injury on the person of Melissa Wolfenbarger. And I'm saying it's serious violent injury because it wasn't a natural death. The circumstances create really the only reasonable inference is that this was a homicide. And so I think if...
Again, don't disagree with you that maybe the inference is that it was a homicide. The question is there a reasonable inference that it was an aggravated assault that caused a homicide?
And I guess what I'm saying is it is impossible for her to have been murdered with an intentional act.
Without having also had an aggravated assault.
That is correct. That's correct. I don't
With
see a
an
scenario where
object.
that's possible. That's why I mentioned poison. Any object that would cause the death of Melissa Wolfenbarger with an intentional act would fit a category of an offensive weapon.
Okay. Thank you. Mr. McDermott, your response, sir?
What I hear the state saying is we can't eliminate every other reasonable possibility. And in the circumstantial only case, that's the standard by which it gets judged. It has to be. You're about to read jury instructions to the jury that says if the state has not excluded every other reasonable hypothesis.
Right, but that's a decision for the jury, not for me
No,
necessarily.
not only. There are cases that say that standard can be used during a directed verdict. Wood v. State, more recent one, I don't know the number here, if you want to look at it. Stack-Thorpe v. State, that was a 2004 case. It was a negative case, but they upheld the same standard, that you may use that on a directed verdict. And what I hear the state arguing is they're basically confessing to you, we have not eliminated every reasonable hypothesis. We can't tell you if it was poisoning, which, by the way, is not aggravated assault by a deadly weapon. It's a whole different category, but they didn't charge. And I was going to say, and the same with strangulation. It is a separate statute under the aggravated assault statute. They didn't charge that. They charged specifically offensive weapon.
Setting aside the somewhat nebulous understanding that we all have because of the circumstances of how Melissa's body was found, am I wrong that the state is allowed to prove, facts that would demonstrate in any way that it might have occurred? I mean, I understand your position is they haven't offered any facts about how it might have occurred, but there are different ways that someone can be assaulted in an aggravated manner, and aren't they allowed to offer facts that would prove any way that might constitute that under the statute?
Well, I mean, they can offer whatever they want as long as the court allows it. But as far as proving what they've charged in the indictment, they have to prove an offensive weapon.
Right.
Okay. It can't be by strangulation, it can't be by poisoning, and they've not eliminated, by the way, that she died of a drug overdose in somebody's house and they panicked and tried to hide the body. There's a lot of possibilities they haven't tried to eliminate. And that's what I'm trying to say. This doesn't need to go before the jury. They don't have proof that an aggravated assault happened. They don't have proof of a deadly weapon. And they don't get to say, well, just let us have a smorgasbord before the jury. It's supposed to work in the opposite direction. If you charge something, you're supposed to be bound by that.
Okay. What, Mr. McDermott, you mentioned the Stack case. Can you give me that citation?
It's Stack-Thorpe, citation 270 Georgia App, 796.
Okay.
The other case is Wood v. State. It's a little older, 156 Georgia App, 810.
Thank you. As I've said, I'm going to deny the motion for directed verdict on the count 1 for murder. I'm going to look at the case line, and I'm not going to rule right now on the DV on the felony murder count, which is count 2 of the indictment.
Understood.
Do we have other witnesses that we'll hear from the defense?
I have one other witness here.
Okay.
I was trying to get in touch with another one who's just not going to be available, except maybe by Zoom. Did we discuss that?